Our objectives during this presentation are to clarify who is a patent examiner and their roles and duties. We will discuss the things examiners may and may not do. The final portion of the presentation will give a simplified overview of the patent examination process. Patent examiners are citizens of the United States and public officials in service to the federal government. We hold at least a bachelor's level technical degree from an accredited educational institution. We are expected to be dedicated to the continuous improvement of the U.S. patent system and interested in fostering a professional environment and image of the USPTO through the courteous delivery of helpful advice and service to customers from inside and outside the USPTO. As patent examiners, we serve as advocates and protectors of the public interest with respect to intellectual property. We provide direct service and assistance to customers from inside and outside the USPTO. We also serve as a judge on patentability with respect to inventions claimed in a patent application under conditions for patentability set forth in Title 35 of the United States Code. As patent examiners, our day-to-day functions include reading and understanding the invention set forth in the specification, determining whether the application is adequate to define the metes and bounds of the claimed invention, determining the scope of the claim or claims, searching existing technology for the claimed invention, and determining patentability of the claimed invention. As we complete our examination and search of an application, we write an office action in which we identify all issues in the application pertinent to patentability of the claimed invention and explain our analysis of these issues as appropriate. If the applicant files a reply to our office action, we respond completely to the applicant's reply. Once prosecution is closed in an application, we either issue a notice of allowance or a notice of abandonment to the applicant. During prosecution of an application, we ensure that all pertinent procedural steps necessary for obtaining a patent are complied with. While you're in the training academy, our expectation for new examiners is that you will not initially be expected to know how to address anything beyond the most straightforward issues. We expect new examiners to be able to recognize issues during prosecution of the case, look up how to resolve the issues in the Manual of Patent Examining Procedure, called the MPEP for short, communicate the issues to your trainer, and learn from the decisions you and your trainer make. A patent examiner is a public servant working as a representative of the United States Patent and Trademark Office. On the next few slides, we will discuss some of the expectations and limitations we have as patent examiners. As patent examiners, we are expected to advise the public on the advantages of and appropriate classification fields for a pre-examination search. We also provide search assistance to the public, but we do not render patentability advice or opinion as to whether an application should be filed. We advise the public on the fees and procedures of the USPTO, which are published in the MPEP and other areas of the USPTO Internet site. We are also expected to advise the public on the advantages of securing services of a competent patent attorney or agent. However, we do not suggest a particular practitioner or firm. There is a list of registered attorneys and agents on our website at uspto.gov that we direct the public to, so that they may choose a legal advocate for their application. In addition to not recommending a specific attorney or agent, patent examiners are prohibited from holding interviews related to an application outside the office without prior official approval and the presence of an examiner or manager who has negotiating authority. We cannot perform a complete search of any kind in any art for a member of the public, nor suggest a field of search for a U.S. patent. We can, however, provide limited assistance to the public in conducting a search, such as providing a reference showing the state of the art. Similarly, We do not comment on the patentability of an invention for which an application has not been officially filed. In light of the presumption of validity, see 35 U.S.C. 282 USPTO policy as set forth in MPEP 1701, patent examiners may not comment on the validity, invalidity, patentability, or unpatentability of any claim in an issued U.S. patent. We also do not share or discuss an application with any unauthorized person. This would be anyone who is not an employee of the USPTO, a registered practitioner, attorney agent, authorized to act in the case, or an applicant or named inventor of record for the application. If you are ever unsure about speaking to someone about an application, check with your supervisor before having the discussion. We are also barred from responding to media requests without consulting the Office of the Chief Communication Officer, from speaking publicly on behalf of the USPTO without prior official approval, and from testifying as a patent expert. There are strict ethics rules for all government employees and some that apply specifically to patent examiners. Information on the ethics rules for the USPTO can be found on the intranet on the Office of General Counsel website under the Ethics link. We may not receive outside compensation for patent-related services performed or advice provided. We also cannot accept free trips, dinners, or other gifts from any members of the public where the acceptance of such gift constitutes a conflict of interest with respect to any service provided or where acceptance could be perceived as a conflict. If you are not sure if you're in conflict with any of these activities, please contact your supervisor. As an employee of the United States Patent and Trademark Office, an examiner is also barred from prosecuting or helping to prosecute an application either in his or her own name or that of a third party. For those who may have been registered to practice before the USPTO prior to coming to work here, you will contact the Office of Enrollment and Discipline, who will provide you with information so that you may voluntarily render your registration number inactive. As set forth in United States Code, Title 35, Section 4, during employment and for 1 year thereafter, you are prohibited from applying for a patent and from acquiring, except by inheritance or bequest, any patent or any right or interest in any patent issued or to be issued by the United States Patent and Trademark Office. This statute also applies if you have an application filed before the term of employment. Please direct any questions you may have to the Ethics Division. We must make sure that we do not falsify our official time and attendance reports. When we certify our time in our time and attendance system, WebTA, we are legally stating that we have accurately documented the time that we worked. Care should be taken to make sure it is correct. Please contact your supervisor or trainer if you have any questions. We may not take credit for work not performed and may not use unauthorized signatures. We also may not misuse or remove without authorization government property or misuse government time. This includes the misuse of the Internet. There are rules of the road for use of USPTO IT resources. If you have any questions about them, again, contact your supervisor or trainer. The penalties for violating any of these prohibitions may include reprimand, suspension, removal, and/or criminal prosecution. We will now walk you through a simplified view of the patent examination process. To begin, you first select an application to examine from your PALM docket in PE2E Docket and Application Viewer. PALM is our application monitoring system. It houses the bibliographic and status information regarding a patent application. PE2E DAV is our electronic application navigation system. It will show you the contents of an application and all the correspondence related to it. all of which is known as the Image File Wrapper, or IFW. Step 2 is to review the application for formalities, formulate a search strategy, and perform a prior art search. As a new examiner, you will receive assistance with the search strategy and prior art search from your trainer, supervisor, or a primary examiner in your technological area or art. We have available many tools to perform our search. East and West are our in-house search database systems for searching U.S. and some foreign patents and published applications. We also use commercial databases such as CAS, IEEE, or ProQuest to search for references which are pertinent to the application being examined. In the next step, you will review the prior art references you have gathered, decide with a trainer or primary examiner which references apply to the claimed invention, and author an office action using the OAKS system. OAKS, or Office Action Correspondence Subsystem, is a program based on Microsoft Word, which includes form paragraphs and other job aids to assist you in drafting an office action. Once the office action is drafted, your next step will be to forward the action to a supervisory patent examiner or primary examiner for review and signature. OAKS also facilitates this paperless review and approval process. All of the communications sent to an applicant by a new or junior examiner are signed by both the junior examiner and examiner with signatory authority, which would be your SPE or primary examiner. Once they have signed and approved your office action, it is then routed to the Office of Patent Examination Support Services, OPES, for recording in PALM. In the next step of our process, a Legal Instruments Examiner, or LIE, in OPES will give the office action a final compliance check and then forward the office action to a contractor for mailing to the applicant. The office action is also scanned and indexed into the Image File Wrapper system for archival purposes. What happens next depends on the applicant. Applicant will typically submit a reply addressing the issues raised in your office action. If they do not submit a reply within a prescribed time period, the application is abandoned. If they do submit a reply, then the examiner must respond to that reply. This process, known as patent application prosecution, continues until the application is either allowed, meaning it will issue as a patent, or abandoned. In conclusion, you should now have a basic understanding of the role and responsibilities of a patent examiner. You should also know what actions are not allowed for patent examiners. As you progress through training, please consult the MPEP for guidance on our practices and procedures and seek the advice of your trainers, supervisory patent examiners, quality assurance specialists, and other examiners if you have questions.